Welcome to the latest episode of Certum Group's podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar on the latest litigation trends and strategies. I'm your host, Kevin Skrzysowski. I am an attorney and a director at the litigation consulting firm Certum Group, where we offer innovative litigation risk transfer solutions in the form of litigation finance, litigation insurance, and consulting services to major law firms, boutique firms, and corporations. Today, I am pleased to be joined by an excellent commercial litigator and a dear old friend who was one of my first guests on the program when I started it way back in 2021. I am pleased to introduce Richik Sarkar, a partner in the Cleveland office of Dinmore and Scholl. And among other things, he is also the creator of the Litigation Lab, a newsletter that addresses innovative strategies and unconventional thinking in the world of litigation. Good afternoon, Richik, and welcome back to the show.
Thank you very much. I am very pleased to be here again.
Wonderful. Glad to have you back. Maybe we should start by doing a little bit about your background and your motivation for creating the litigation lab, starting with the word of commercial litigation is quite broad. Tell us a little bit about your practice and how your experiences have shaped your perspective in the field.
Yeah, I mean, I have been practicing commercial litigation for about 28 years now. I came right out of law school. I worked for a judge. After that, I literally crossed the street and went to a law firm,
Hmm.
Thompson Hine, and joined their litigation practice. Um, and my practice has evolved from doing a lot of different small things. Now I do a few really big things. So I
Okay.
have class actions. Uh, I hesitate to say complex commercial litigation, because I really don't think anyone would admit to be doing simple commercial litigation. Um, but I have been doing that sort of work for a very long time. The niche that I kind of focus on is representing retailers or retailer adjacent companies. And so I have a lot of experience with consumer practices, consumer statutes. I also then, when you represent that many companies, and you also end up representing them in their supply chain line. So then I do a fair amount of, business to business litigation as well. But by and large, it falls into the category of consumer protection in a number of different consumer facing industries, including retailers, banks. Essentially, if you are working with a consumer customer base, I probably have worked in that industry and
Hmm.
represent companies in those industry in that litigation. That has kind of evolved into also a compliance practice, because it's not just, you really don't want to just be a plumber and come in and fix the leak. You want to also explain to your clients, listen, this is the pipe that's busted. Why don't we just fix the pipe?
Right. Get the origin of the problem solved first. So,
Yeah. And then I do, as part of my practice, and initially I did a lot of bank litigation. I still do a fair amount of bank litigation, but that also led into data privacy litigation. And I joke with people, my first class action in data privacy was when a dumpster was stolen from a bank that had people's personal information in it. And so I had to, essentially it was a data breach. All these people's information was taken, and we had a few people that alleged that their identity had been stolen, and this parade of horribles happened. And we litigated that. I think we ended up settling it on very, very favorable terms. But I can tell you that the laws really have not changed that much since that first data breach that I dealt with. We've just applied them to different circumstances.
that's a wild
So
story. I mean, I'm
yeah,
only familiar with electronic data breaches. The fact that somebody actually physically stole paper with names and data on it, that's
well,
never heard.
even more interesting, first they broke into the dumpster. Then a few weeks later, when the dumpster was locked, they stole the entire dumpster. Just picked it up and took it.
That's wild.
Um, so it is uh, I do a lot of data privacy. I do a
Sure.
lot of governance work in that area where I counsel boards. I used to be a chief privacy officer for a large law firm, which so not only were we responsible for the employee and the law firm data, but we were responsible for all the client data that was on the system. And understanding that made what we did even more important with respect to data privacy and things of that nature. And then the final third part of my practice is, we've been friends for a long time. Some of our friends have done very well, and some of those people now need someone that can, without any sort of bias, tell them if something's a good idea or a bad idea. And you have the benefit of a lot of history and
Mhm.
and validation of being right. So they listen to you when you tell them those things. And so that's like I'm the outside general counsel for a few people that need that sort of service.
Nice. Just solid, honest business counseling.
It's a lot of citing to them the Jeff Goldblum line from Jurassic Park. You got so excited that you could do something. You never thought about whether you should do something. Um,
Sure.
and I just remind them that,
Yeah.
the fact that you can is fine, but do you really need to? Do you really want to? Why would you want to get into this particular line of business?
Yeah.
Um, so
Very sound advice. And I know you've had a varied career when it comes to class actions and complex litigation and data breach. So let me ask then, when it came to creating the litigation lab, what inspired you to do it? Did you see that there was a hole in the media market, or was there like a particular event or catalyst or accumulation of them that you thought, I'm going to create something because I see there's a need?
I think it was less of an assessment of a need in the market and more of understanding that Substack specifically provided an efficiency for me for the market.
Hmm.
I cannot profess that looked around and said, I don't see anybody else doing stuff like this. I didn't really concern myself with that. What I more concerned myself with was I have a lot of different sort of ideas that I like to explore, and I needed a place to store them initially. But then I recognized that this could also be a place where I do some market research. So I come up with an idea that makes sense to me. Um, then if I can develop it into, a 200, 300, maybe 500 word article,
Hmm.
then I know I at least have something there. Then I post it to my Substack. And, I've done two posts so far. And so I went from 0 subscribers, because my parents don't have Substack. So I couldn't count on those two people
Sure.
getting on Substack. And now I'm at around 100. So um, I think that I'm going up around 25 people every new post. I don't want to be too over ambitious with it, so I've decided to do it quarterly. But I have
Okay.
ideas I store, and then I just kind of develop it. So let's take, for example, the very first one. The first article I wrote was an article about how defense side class actions, which are plainly set out in the rules of civil procedure, but very rarely used and pursued, could be a way to address certain market limitations now with respect to litigation. We've eliminated the ability to get nationwide injunctive relief. We've eliminated uh, certain the deference to certain agency decisions. Those two things mean that there are probably going to be a lot of individual cases being brought, and which then leads to the possibility that there'll be a number of competing rulings coming down the pike. So let's use, to bring it a little bit full circle, I first spoke on this podcast about TCPA cases.
Hmm.
Well, there was a decision last year by the United States Supreme Court that said, listen, the FCC's guidance and the FTC's guidance, for that matter, implicit in there, is useful, but is not binding. Courts still need to look at these decisions
Right.
and make their end these cases and make their own decisions. So we have a lot of TCPA related case law that's out there that potentially could be undone. In many instances, I think rightfully so, but could be undone by courts uh, once one at a time. But if you think about what a defense side class action would be, you could go through and say, I am not aware of, I have an issue, and I think there are lots of defendants out there that that uh, would be affected by this, and I want one decision that will cross a bunch of jurisdictions and a bunch of different types of defendants. So in a TCPA case, for example, for a while I would litigate cases and on some class actions if the plaintiff in the class action uh, also ended up a lot of those cases resulted from collection activities on debts.
Hmm.
If those individuals actually owed money to my client, sometimes we would counterclaim as part of our case that they owe us money and here are the terms of the agreement, so we could get the terms of the agreement in play and then utilize that in order to advance our cause a bit quicker with respect to terms and conditions that were there, with respect to waivers, limits on liability, consent, that sort of stuff. Now,
Interesting.
having
Yeah.
having done that in the past, it occurred to me that if I wanted to vindicate a client's clear policies and procedures or clear, terms and conditions, I could countersue in a class action and say, you know what, we would like a declaratory judgment that our terms and conditions are right. That is a perfectly reasonable defense side class action tactic. It's, one of the few things that you want. And the article actually goes into what would be the optimal sort of situations that a corporation might want to use a defense side class action. But we'll use the terms and conditions. So we want to vindicate our terms and conditions. We want to show that these things are valid. And so we're going to countersue and we're going to seek a defense side class action for the consumers that are out there that the plaintiff's counsel in this case purport to represent. And that would then eliminate a real fight over numerosity, commonality, because they're
Sure.
asserting they already have it as part of their class.
So you don't
And
you
so
don't need to
that
argue with those. You already have the main principles in play
that's right.
and proven. So yeah,
And
that
so if I'm in the right jurisdiction, I might want to do that in order to get a decision that will go across plaintiffs and jurisdictions, not something that will just affect this case in front of me. So, I toyed around with that idea for a bit
mhm.
and decided that this would be an interesting article, but rightfully so, some publications didn't really, jump at the chance to, have a little bit of a civil procedure lesson.
Yeah.
And so I just wrote it myself, put it up on my Substack, and that's when I was like, we're just experimenting with ideas here, and that's why
Hmm.
how we came up with Litigation Lab as the name of. I shouldn't say we; it was just me. That's how we came up with the Litigation
Sure.
Lab as a name. And there are all sorts of different ideas that are out there that you could kind of play around with. For example, my second article um, was about how, with all the information that's out in the world today, and the way that you can harness it a bit better with AI, plaintiff counsel organizations do the same thing that a lot of defense counsel organizations do. They have CLEs about what are hot topics in their industries, things that they need to adjust, things that they can talk about with their plaintiff counsel brethren. Who, and I will tell you, some of them are the smartest attorneys that I've met. Some of them
Oh,
are,
sure.
they're. I don't want to. They're not. There are some people just like on my side of the V that may not be as qualified as I think they should be to pursue the cases they are pursuing.
Hmm.
But I actually don't think that's as many as, you know, sometimes we broadly paint the brush that all plaintiffs' counsels are ambulance chasers, and that's not the case. Um, and they have structure to what they do.
Yep. And they're
I
also
knew
them very, very wealthy as well.
that is exactly right. They have planes, I do not.
Right.
Um, but I realized that they must have, programs that they are publicizing out there.
Yeah, sure.
And so I started asking AI very specific questions for very specific groups and said, go analyze what they've been talking about for the last year by looking at their agendas and what they're talking about on when they publicize these things. And so it gave me a very nice cross section of different claims that were going to be coming down the pike. Um, I think we should be doing more of that. I'm quite confident that plaintiffs' counsel are looking at our agendas and figuring out how we're going to attack certain things. For example, looking at some of these agendas, I think that you're going to see a lot of class action work in bias for AI related decisions. And sometimes, loans are obviously going to be up there. But one thing that surprised me was there's a lot of discussion out there about tenant screening
Hmm.
for apartments and things of that nature, and employment screening. So I think you're going to see a lot of bias related litigation for using AI in these things, knowing that, some of our clients can get a little bit ahead of the curve and start anticipating, what would our defenses be. They can also start, putting out or being more transparent about some of the policies and procedures that they use so that they can point to that when they do get sued and say, listen, we're not a black box. We tell everyone what we're doing. And you can get ahead of the curve on those things and maybe even save, the save your clients some money and strife by helping them kind of fortify their defenses before they get sued.
Yeah. So is that how you're coming up with some of the cutting edge topics, like the description of the program is like bold strategies, testing new theories. You're leveraging AI tools as like predictive analysis based upon meeting agendas on both sides of the V to see what could be coming down the pike.
I will now, after having run that initial analysis,
Yeah.
it is something that is going to allow things to kind of bubble up. The other thing that I look at are the other, I've always believed, and having worked a lot in the banking industry, um, you can predictably understand what is coming down the line by looking at what government regulations are out there. And if the government has decided to regulate in a certain area, more often than not, you're going to find a lot of litigation in that area as a follow-up.
As a
Um,
follow.
yeah,
Absolutely.
you're
Right.
often going to see, and so for that, if you see regulatory litigation on particular issues against an institution, it's a pretty safe bet that a bunch of private plaintiffs are going to sue that same institution
As a
and
follow.
point to the decision and say this already establishes why I have a case, and now this is what's going to happen. So it's a matter of understanding some of the early warning signs and analyzing them so that you can tell your clients these are the things that I think are going to come down the pike. And this is why I think that, because the source of my information are plaintiffs' counsel agendas, or they are regulatory actions taken by states and governments, and people are going to start following down that blazed path.
No, I think those are really smart ideas. In terms of AI, I know you're going to start leveraging it more for this newsletter, but is the commercial litigation department at the firm currently exploring or have they implemented any AI programs and for what type of utility or purpose?
Yeah, we're looking into Dinsmore is looking into how we can better use AI.
Hmm.
Um, we are also, but we have to balance that against what information are we putting into the system.
Right. Yeah.
So we do not allow private information or confidential information to go into any AI programs that we use.
Sure.
However, I, if a complaint is filed against one of my clients, I quickly will take that and run it through an AI analysis and ask, based upon, you know, a lot of this is structuring the prompt correctly and limiting the world
Right.
of information that AI goes to look for. So I will oftentimes say, listen, this lawsuit has just been filed in this industry. Let me know what other types of cases that have been filed and what arguments have been made, both by the plaintiffs later on in the litigation or by defendants addressing the litigation.
Yep.
As it's a publicly filed document, I don't feel
It's
I'm
public.
not worried about the information getting used in training the AI program out there because it's already out in the world and has probably already been used in a number of different AI programs. That's very different than getting a report from a client and plugging it in, going, "Hey, what do you want in here?"
Oh yeah.
I also
Summarizing some full
encourage,
paragraphs. Yeah.
yeah,
Yeah.
I also encourage people to, if you're going to be filing a motion, strip out the client identifiable information, even if you know you're going to be filing it and it will be public at some point. Until it is, you should not feel comfortable putting it into AI. But at least, you know, ask AI or ask your different program, here are the arguments that I want to present. Let me know if I'm presenting them in a clear and logical way, if
Right.
there are any gaps in my analysis, and let me know what counter arguments I should be expecting. I use it more as a way to harness information than have any sort of discretionary role in what I do. My clients pay me for discretion and commercial
Right.
judgment, but they like to save a little bit of money in analyzing all the information that's out there. So I think that in the legal profession specifically, the highest and best use of AI right now is in gathering information, analyzing information, and then allowing an attorney to make decisions based upon that analysis and summary and things of that nature. I would never say write a brief
We
AI.
know what's happened to some people that have
Yeah.
asked programs to do that. It's not
I,
going
I
to
would
them.
tell it to give me a draft outline for a brief based upon these things. Or if I've written a number of different briefs that I've filed, I might ask it to do a first draft based upon what I've already done and
Created. Yeah.
utilizing the law that I've already utilized. Because I've limited the world of it to those things. And then I vet it anyway. I have it, either I vet it or I have an associate vet it to make sure that
Right.
everything is still okay. But it does save some time. And, you know, I don't want to say that it is not something that people should be using. But that'll be part of what the litigation lab does is what's the extent of how we should be using it? Are there best practices?
Right. Yeah.
In, maybe a good article, and I just thought of it, so I'm gonna have to write it down and think about it later on, is, writing an article about the process of using AI to write a brief or the process of using AI to answer a complaint and kind of run through, these are the things, these are the prompts, these are, this is how I would do it.
No, all really good ideas. I use it for largely the same ways. It's super helpful when you get a 100-page complaint in the door, and you can ask it to summarize the key arguments and raise potential defenses, and it does save hours there. Speaking of just commercial litigation in general, and maybe some of the impetus for you to create this newsletter. Do you just see some conventional approaches in litigation that are maybe like staid or outdated, but you keep seeing people employ them, over and over, that need a more enhanced modern approach? Or maybe I should rephrase that and say, like, what do you think are some of the biggest just challenges in commercial litigation these days that could be solved by leveraging technology or AI or possibly some new theories?
I think that one of the things you could use AI for is understanding how certain issues have been addressed in other industries and extrapolate from that what you can do in the industry that you're working in right now. So, for example, in the insurance world, there used to be a number of lawsuits with respect to the types of parts that were used by companies in doing repairs and what was authorized and what was not.
Hmm.
That started with cars. Then the next thing I knew, I saw it was applying to boats. Then I
Right.
saw that was being applied to RVs. Well, by the time it got applied to RVs, those RV manufacturers should have a pretty good idea of how to argue against those things because two other industries had already done it. And
Right.
I think that, AI will allow you to kind of look back at other defenses and then help you extrapolate ideas as to how you can use it in your defense. More importantly, it can help you kind of frame the argument in a way that is better digestible. And you can just ask it, I would like a clear and logical analysis of this written in plain English that explains, the different theories. I think that you could also use it in analyzing, I have a number of standard affirmative defenses that I employ based upon the type of case that I'm in.
Mhm.
I actually have a list of them. And whenever I get a complaint in, I highlight those things that I want to include, give it to my secretary and ask her to do that, put that in my first draft so I can kind of take a look at it. That's the sort of thing that not only can you do maybe a little bit better with AI, you can then ask AI to consider other affirmative defenses based upon these that might make sense in this particular situation. You could also ask it to help in drafting some fact specific affirmative defenses that might not immediately jump out because it's not a boilerplate sort of thing. But it can help you phrase issues and ideas in a way that you might not have otherwise thought, but might be very helpful in this process. I think you could also use it in a manner of understanding some affirmative defenses and incorporating that a little bit more into your actual answers to allegations. Too many times, as an attorney, you get a complaint and you limit yourself to admit, deny for want of knowledge. I oftentimes will say, I admit that this occurred. However, and then I actually start putting out my narrative in my answer so that, assuming that that will be the first time that a judge will see what my side of the case is. I might as well give them some details as to my side of the case, as opposed to just saying, I deny everything that they say, and you won't hear from me for quite some time until after discovery is done or maybe some motion practice is done. I think that's a wasted opportunity. I think that that's someplace where you could use your answer to be a little bit more of an advocate for what is going on in a case and presenting your client's view right away. Because most courts will look at the answer, they'll look at the affirmative defenses, um, and I think they are pleasantly surprised when they see more detail in these
Sure.
things. I've had courts during the status conference say, "Hey, listen, during in your opponent's answer, they assert this. What do you say about that?" And it puts the plaintiff on the defensive because all of a sudden, they, depending on the nature of the case, if it's something that is one of those things that often that counsel is often filing, um, they may not understand all the facts of the situation. They just know that someone came to them and said, "I've been getting text messages for a very long time, and I don't believe that I ever gave my consent." Well, in my answer, I will sometimes say, this relationship occurred, and on this date, our records indicate on this day they opted into this program.
Right.
Why not? I mean, why not put it in there? Why not put it as an affirmative defense? Um, why not, think about based upon that, if it's something that I'm relying on a document for, Let's think, is there a creative way of using this document as part of my answer or my pleading, be it just attaching it as part of the answer or doing a counterclaim on it, um, to be a little bit more assertive and maybe even give me a few more extra outs, um, in the long poker game that these cases can be.
It's definitely a very interesting strategy. So, in terms of the litigation lab, I know you've written the first couple of articles, um, but your subscriber base is growing pretty quickly, and people are commenting on this and sort of driving where the thought leadership's going to go in the future. Are you opening this? Is this open source for other people to contribute other thoughts and ideas as well if they were interested?
I haven't thought about that,
Okay.
because I really meant it to be something that I was doing. I
Yeah.
think if someone reached out to me and asked, "Hey, listen, um, I have this idea. If I liked it, I might ask if we could, write something together."
Author? Yeah.
But
Sure.
I don't know if I want to just let anyone post on that link. I think that that person could go and start their own Substack. And if I like the idea, I could share it via mine.
Yeah.
Um, but right now, I don't foresee letting other people just kind of put stuff out there unless I felt very comfortable with them, their knowledge base, and the idea. I mean, I might be comfortable with them and their knowledge base, but don't think the idea is very good. Um,
Right.
so,
No,
you
then you're
know,
serving as your own editorial board.
yeah,
So,
exactly.
yeah.
So right now, I just want to make it like a quarterly thing. I want to, as ideas come up, I kind of keep track of them and decide how I want to develop them. And that is fun for me, actually. Like every now and again, I like to kind of I mean, we've known each other a long time. I like to, you know, take things and turn them around and see if there's different ways of arguing things. Um, are there different perspectives on a problem that I'm just not seeing because of where I've always been on these things? So I like to kind of pivot things in my head. And that's another place that, AI is very helpful because it can, it might come up with 15 terrible ideas, but it might have three or four really good notions in there. Um, and, you know, those things might want to be developed a little bit more. You might want to, um, potential defense arguments, some of them might just not be worthwhile. AI has overthought the issue and it has done too much of one thing or the other, and it's come up with a very aggressive and maybe tenuous argument. But there may be something in there about um, that's worth exploring because if remember AI is you know even though AI can generate information, it is still using other people's knowledge as its information base. So some of these things it may be proposing because there's some sort of critical mass of documents out there that did the same thing, and that's why it's proposing it. So it might be worthwhile to look into it if it's something that aligns with what you think and what you do. Because what you don't want to do is just subset out, sublet out your discretion to
Right.
a
No, right.
program that considers bad documents and good documents to be exactly the same.
Right. No, that makes perfect sense. But I also think that what you've created is a repository for novel ideas, like we were speaking before the
Yeah.
call. And depending upon the number of likes and reposts, if you have what you think is an outside of the box idea, maybe it wasn't so good. But if you get tons of likes and reposts, then
Or comments. Like I love comments on these things. I'll have
yeah,
people that will be like, "This is a really interesting idea." Um, yeah, it also then becomes a bit of market research.
yeah,
Yeah, how would this work? Would this work?
yeah. It's
I
market research, really. Yeah,
yeah, I kind of wonder if at a certain point in time, I suspect that some plaintiffs' counsel or some people that are on the plaintiff side of the V um, may also be reading these things, and that's fine. I mean, I'm not saying anything that isn't out there
that
in
was
the
going to
world
be
to
my
consider.
final question to you, actually, which was, you're a defense counsel. You're thinking of defense strategies, but who's the intended audience? defense lawyers, your clients, in-house counsel, but not quite necessarily the plaintiff's bar as of yet, or judges?
Um, Primarily it is other people that want to think creatively about these things. Some of those people will fall into the category of other defense counsel. Some of them will fall in the category of in-house counsel. Some of them might fall in the category of just people that like the law and are interested in
Sure.
these ideas. Um, Ideally, though, I'm hoping that it will speak to people that are in a position to make decisions about some of these things. Because you can propose an idea all you want, but if you don't get a client that will let you actually go pursue it in litigation, it's just a tool that's in your toolbox that's never used. I have a couple of different, wrenches that I got, when I got my toolbox as part of our wedding gifts. I still don't know what those wrenches are.
What's
I'm
normally
sure that
the
they're
deal?
very
Sure.
useful in some sort of situation.
No, same
So
exact thing. Yeah.
exactly. I want to avoid, some of these ideas being that sort of tool. But you're going to, I think that if you get a critical mass or you get enough people that say, yeah, that's an interesting idea, I'd like to pursue it. Um, it's that sort of thinking. So that would be, in some instances, in-house counsel. It may be, CEOs and CFOs of companies
All right.
that are looking for people that are thinking outside of the box as far as, everyone's litigator gets the complaint in, says, okay, well, I need some time to file the answer or a motion to dismiss. Um, I need some time, and then we're going to do discovery, and then we'll ask for a mediation. And in between there, we'll try to figure out settlement, structures.
If it's a
Um, I think
possibility.
that this is a good way of, being a little bit more creative of, is it better to not wait to do a deposition? Like, should I do a deposition right away to figure out all the answers before they do any, before even any discovery or documents are out there? A lot of times I already have all the documents I need to do a deposition, but I conform to the structure that I was taught almost in the order that they are in the civil rules. Um, Instead, maybe I should, change how I do it. Maybe I should change how I think about doing things. Again, being more aggressive with respect to counterclaims and things of that nature, so that you're putting the other side on their back foot. And they now need to make some decisions about what's going on. I think that, especially in the area of consumer protection litigation, because of the different laws that are out there and compliance programs that companies have, they may have more tools at their disposal that they could use in defending themselves against these things. And they may want to bring them out, sooner rather than later, and, try to get things done. Because, sometimes for both sides, a lawsuit, even being sued and suing someone, for about the first 90 days, there's a lot, maybe 45 days. There's a lot of activity. People are thinking it's top of mind for a bunch of people. After that, everyone goes back to their day job. And, in-house counsel of other cases that have been filed that now take up their time. Plaintiff
Mhm.
counsel, this is a piece of inventory on their shelf that, you know, it's great until they get the next piece of inventory on their shelf. Um, Business people who are very interested in pursuing claims initially, they actually, litigation isn't their job. So now they need to start moving on to the next thing. So
Absolutely.
I think that we need to have better 45-day strategies as to how to, from the day that something gets filed or from the day that you answer something, is there a way in the first 45 days to get out of this case or to resolve this case and to
Right.
minimize your spend on this case and talk about, you know, maybe that might be a time to engage the other side in conversation about the arguments that you will bring so that they can determine how much work they actually want to do on this. And if you have that conversation sooner rather than later, you are able to get your client out of things much quicker. And I am a firm believer that litigation and home improvement have the same good, fast, cheap triangle,
Hmm.
and you can only get two at any one time.
Ah,
So,
great. We encourage those discussions early in litigation as well, but of course,
yeah.
we do insurance and finance, so we're looking forward to that all the time, and
Well,
but clients
thinking
really
of talking about
appreciate it.
your business, one of the things that I'm probably going to be looking at is getting an better understanding of the types of things that is attracting litigation funding right now.
Yeah,
Because there are going to be very specific types of cases that attract litigation funding. Right now there are a number of cases out there that relate to certain statutory claims
hmm,
that I think are probably being, I think a funder may have decided that they have a hammer and now they're going to go look for a bunch of nails. And I think that if you can, that sort of stuff kind of bubbles up. Um, you know, there are a number of legal publications that have people that just focus on litigation funding and funders.
sure,
And I think that if you can better understand the types of claims that litigation funders are pursuing and sometimes maybe even creating, um, which is not a pejorative. I'm not saying that they're making it up out of whole cloth. I think that, you know,
right,
they're figuring out ways to deploy their capital. They're going to be safe about it. So there's probably something there that they can pursue. But understanding what those things are may be very effective as part of creative, another new early warning system that litigators should be monitoring.
yeah, and I'm happy to have that conversation with you or provide some quotes for an upcoming article if you're interested. But I know that working through a third-party funder pressure tests legal theories and
Well,
theses.
you fall in the category of people who I've known for a long time, and I trust your information.
And
And
thank you
once
very
we
much.
talk about these ideas, I'll decide if I like them or not.
Yeah, sure, sure. But unless if you don't win, everybody loses, and so
Yeah,
yeah, that's the thing
there
about
are definitely, there are very few. I mean, there are many judges out there who have the attitude that all cases can be and should be settled. Um, and so they kind of deal with things that way. Um, I don't know if all cases fall in that category. I know many of them do. Um, and understanding that makes it easier sometimes to kind of broach settlements with my clients of these are the things that we should have a go no go line. Like
yeah,
up to this point, we're happy to settle this thing, but if it if we can't, then no go on settlement and let's go and defend this case. Let's go and show because
take all the
sometimes
way.
you have to understand that people need to understand that sometimes plaintiffs counsel are as afraid of a bad verdict as defense counsel are because one bad verdict in a defense side class action against a bunch of consumers where you're trying to vindicate your terms and
Bad for the
conditions,
brand.
bad for the brand, guts that particular line of cases, and
Yeah,
now they can't file that case anymore. Sometimes you don't want the answer to the question.
very good point. Excellent. Well, listen, Richard, this has been a very interesting, enlightening, informative conversation. I think the audience will think the same. If somebody wants to get a hold of you or
Mhm.
sign up for the litigation lab, what would be the best way to do that?
I think through my Substack. And I'm a very bad marketer of my Substack because I don't know the link right off the top of my head.
Yeah.
But I'm pretty sure that I'm the only Richik Sarkar that has a litigation lab on Substack.
So
So I think if you just use the
it's
Google
on
machine,
Google.
yeah,
Yeah. Yeah.
or Yahoo or Bing or whatever it
Or
is,
Bing
whatever
or whatever
search
you,
device
yeah.
you like.
'Cause I
Copilot,
searched,
perhaps I'm in the Copilot now, but I would look up Litigation Lab Richik Sarkar,
yep,
and that's the easiest way. It's also something that I on my LinkedIn profile. It is you can link to it through that. I have
right.
my website link on my LinkedIn profile. So Richik Sarkar on LinkedIn would be that's an easy way of doing it. Also, just reach out to me. I'm Richik Sarkar, Richik.sarkar at dinsmore.com
There you go.
for my office email.
Yep, and they will find you, and they'll find you. I found you all over the internet earlier, so I'm sure it will not be too easy. Let's see. Last but not least, let me thank the audience for listening. If you'd like to get a hold of me to talk about any litigation, insurance, finance, or consulting services, I'm at certumgroup.com. Kevin Skrzysowski. If you want to listen to the program, all the podcasts are on our website. They'll be on LinkedIn, Apple, Spotify, Stitcher, like 10 different podcast outlets. So um, you can easily find this program and all of the historic programs over the past 4 years right there. Richik, good to see you. Thanks again for rejoining the program. I enjoyed the conversation.